let's go to our key takeaway section. Everybody take 2 to 4 minutes, starting with you, Joella Van Over. And what are the most important things people should leave today's webinar with top of mind, and things they want to look at for their business on the contractor side of this equation?
Sure. I think that having a good security plan that's required by NIST and updating your plan continuously if it requires updating is the most critical thing. The issue is that security plans are not stagnant documents. Contractors in reality need to evaluate and reevaluate new risks and new tools and changes to their system that implicate their security plan. So I think the ongoing nature of having a security plan that you actually don't just stick in the drawer, and an incident response plan that you update, and continuously making sure the flow of information within your organization is such that you can do that effectively to actually protect your organization and DoD and other agencies is really the most critical thing. And one other issue, for those small businesses that are terrified about this December 31st compliance, there are actually some companies out there who have compliance that they can implement actually very quickly. It's cloud-based, but it's possible and it's not terribly costly. So that's just a reminder that it's better to comply than to ignore, and there are some less costly ways to do that.
All right. For those who want to do business with the government, particularly the Pentagon, Gus Gisani, what should people leave today with?
Well, so my focus is on the actual cybersecurity requirements in 171, mostly. So they actually ought to look at that document, read it, try and understand it as best they can. In the back, there are tables, particularly Table D, which provides reference to another document that provides more explanation. The requirements are actually not that onerous. They're basic cyber hygiene. And so take a look at it. Don't overthink it. Don't read more into those requirements than are there, and just start working your way through it.
Mary Thomas.
Yes, I would say if you are a contractor who gets a contract that has this clause in it, the first thing you need to do is really understand what is the information that is required to be protected. And if that's not absolutely clear to you, you need to have a conversation with the contracting officer so that he can get that clarification from the requiring activity, because that becomes very important, especially when you start looking at how that information flows down to your supply chain. It's also important to read all of that DFARS clause, understand what's in there, and all of the terms of the contract, because often there are other things in that contract that will also impact how that DFARS clause is implemented. And so reading all of that up front and having a clear understanding of it and getting clarification when required is really the best first step.
All right.
This is Gus. I would add to Mary's comment that since this clause goes in every DoD contract, there will be many contracts where the clause is there, but there is no covered defense information provided to the contractor. So don't jump to the conclusion you have something to protect when you don't, if they're just buying screws from you.